One of the questions often asked about Singapore is how and why Singapore has managed to be where it is as a bastion for arbitration, not only in the region, but internationally as well. Allow me to try to give you my take on this. Firstly, we are seen as a neutral venue with a clean, green, efficient government. Singapore is a state known for low corruption. We have a strong, efficient judiciary coupled with strong rule of law. Furthermore, Singapore has a rich international pool of legal talent. Most, if not all, the international law firms have a presence in Singapore, and this is in addition to the major Singapore law firms, and certainly the top 4 to 6 Singapore law firms are capable of matching the very best anywhere in the world. Take, for example, ourselves, Rajah Tann. Even though we are a Singapore firm, we have since developed a network of law firms across 9 other jurisdictions, and these would include places like Malaysia, Thailand, Vietnam, Cambodia, Laos, China, and by early next year, we will have Philippines on board as well. Just in Singapore alone, we have a strength of about 350 lawyers, and across the entire span of our various offices, we have well over 700 lawyers. So this gives us the necessary depth and width to deal with the most complex cross-border disputes. And increasingly, we have been dealing with disputes of all forms, including investor-state disputes, as well as treaty arbitrations. Furthermore, Rajah Tann is unique among the Asian law firms. We are the first Asian law firm with a standalone arbitration practice group with about 10 partners and close to about 30 lawyers. More importantly, we were the first Asian law firm to crack the top 30 in the respected GAR publication for international arbitration practice groups. As a firm, we have been in the forefront of international arbitration and all forms of major disputes in Singapore and in the region, and we had also been involved in some of the biggest international insolvencies, including Lehman Brothers, which I personally led across Asia. Apart from a strong corrupt-free judiciary and a rich international talent pool of lawyers, Singapore has a broad suite of options to offer litigants. In particular, there is international arbitration, there is mediation, and there is a new division of the Singapore Supreme Court known as the Singapore International Commercial Court. I was on the working committee that recommended the formation of this court, but I will leave my partner Francis Xavier to elaborate more about the SICC, which is the acronym by which the Singapore International Commercial Court has become known. Furthermore, in support of international arbitration and dispute resolution in Singapore, there is a strong legal framework with well-trained, well-qualified judges who are familiar with international arbitration, as well as major commercial issues arising across the world, and they are well placed to deal with matters arising from arbitration awards. Before I talk more about international arbitration in Singapore, allow me to say a few words about the Singapore legal system and Singapore law as a choice of law. It is fair to say that over the years, Singapore has gained popularity not only as a destination for international dispute resolution, but more importantly, Singapore law has found its way into the hearts of commercial contracts between parties as a governing law. This is important because in the context of people coming in to do deals, investors, joint venture partners, and so on, very often there are foreign parties coming in, dealing with regional parties. Both sides are looking towards finding a suitable, neutral venue for the resolution of disputes, as well as a neutral choice of law, a neutral law to be the governing law of the contract. Singapore offers itself on both fronts. For example, if you were to take an American party investing into China, the Chinese party probably wouldn't agree with New York law. The US party would not agree upon Chinese law. And if we were to look at a compromise, a neutral compromise, Singapore becomes a real option to be considered by the various parties. Not only with Singapore law as the choice of law, but Singapore as a neutral venue for the international dispute resolution, which may arise out of any conflicts in relation to the contract. Let us look at the factors favoring Singapore as a choice for dispute resolution center and Singapore law as a choice for the governing law. The Singapore legal system is entrenched in the English legal system. Singapore was a former colony of the United Kingdom, and we inherited much of the English common law and the English legal system. In Singapore, there is also the reception of English law through the application of the English Law Act, which provides for the application of English commercial law, but modified to suit local circumstances and the modern times. Furthermore, Singapore is a party to many commercial law treaties, and purely as an example, Singapore has signed on to the following. Firstly, the New York Convention for Arbitration. Secondly, the UN Convention for Contracts for the International Sale of Goods. For trademark protection, Singapore has signed on to the Madrid Protocol, and there is, of course, the Hague Convention for the Choice of Courts Agreement. In addition, Singapore is a major financial and commercial center, and the judges and the lawyers have wide, significant experience in these areas. Relating back to the Singapore legal system, what is paramount here is that the Singapore legal system offers provisional remedies as well. So in this respect, the Singapore courts could assist in relation to various matters by issuing either injunctions or stay orders. Purely as an example, injunctions may be granted by the Singapore courts to maintain the status quo pending the dispute being fully resolved eventually. As another example, the Singapore courts may make an order to stay certain local proceedings on the basis that the matter should go on to arbitration, whether in Singapore or elsewhere. Let me say a few words about arbitration in Singapore. As a preferred venue for international arbitration, I must say Singapore is totally agnostic when it comes to what arbitral rules the parties may choose to apply on whatever governing law there is in relation to the dispute. The focus is on having the arbitrations being dealt with in Singapore, and in this respect, we deal with many different arbitral rules, including the UNCITRAL, ICC rules, LCIA rules, JCAA rules. You name it, we deal with it. For example, there is the Permanent Court of Arbitration, which has a presence in Singapore. I recently came off 2 cases where we represented state interests before the PCA. There is also the ICC and the International Court of Arbitration. There is ICSID, which is the International Center for the Settlement of Investment Disputes. In addition, for maritime disputes, there is the Singapore Chamber of Maritime Arbitration, which is shortly known as SCMA, and that has a panel of more than 80 arbitrators from all across the world. The modern arbitration story in Singapore started in the 90s with the creation of the Maxwell Chambers and the Singapore International Arbitration Center. These were the twin drivers which brought Singapore into the spotlight where international arbitration were concerned. Maxwell Chambers is a dedicated facility for arbitration with arbitration rooms, separate breakout rooms, and all the necessary support that one could require in the course of arbitration. The Singapore International Arbitration Centre has a very wide and well-established panel of over 400 arbitrators from over 40 different jurisdictions. I would be remiss in my telling of the Singapore arbitration story if I did not say some things about the SIAC and certain features about its rules. Firstly, the SIAC is set up such that there is a court of arbitration comprising of 18 practitioners from all over the world, and their main function is to supervise the case management of the SIAC. In addition to the well-established panel which I had mentioned, the SIAC also has a specialist panel of arbitrators for intellectual property. The cases dealt with by SIAC has been on the steady rise, and in 2015, SIAC dealt with a total value of disputes amounting to about $6.23 billion, with an average dispute claim of about $23 million. SIAC recently amended its rules to provide for arbitration to be commenced also not only in respect of contracts between the parties, but for investment treaties as well. Let me explain some of the key highlights of the SIAC rules. First, there is a procedure for expedited arbitrations, or what is called the expedited procedure, and this relates to smaller claims of less than $5 million, and the award needs to be issued within 6 months. The SIAC rules also seeks to strike a good balance between the civil law approach and the common law approach where discovery is concerned. In this respect, the general position under the SIAC rules is for the parties seeking to rely on relevant documents to produce such documents in support of their claims. However, there is the ability for the tribunal to make specific orders for further discovery, i.e. production of documents, in situations where those documents are not only relevant to the case, but also material to the outcome. There is, of course, the proviso that these documents need to be under the possession or control of the relevant parties. So this approach is consistent with the guidelines in the IBA rules for the taking of evidence. Significantly, the SIAC rules also provides for the granting of interim reliefs by the tribunals. And some of these reliefs are as follows. First, there is the power of the tribunal to make an order for the preservation of property or an order to prevent the disposal of properties. The tribunal can also make an order to prevent the dissipation of assets, to prevent any arbitration award being rendered ineffectual. There is also provision for security for costs to be ordered by the tribunal, and rather uniquely, there's also a provision where the tribunal can order security for the sums in dispute. This is a rather rare provision, but it has been invoked in certain occasions. Some examples where interim relief has been granted by tribunals would be in situations where there is an injunction being granted to restrain a call on certain performance bonds, or where certain anti-suit injunctions are being granted by the tribunal to prevent foreign claims being brought in the face of ongoing arbitrations or in the face of an arbitration clause which is being invoked. The SIAC rules also provides for the appointment of emergency arbitrators, and under this regime, the SIAC would typically appoint an emergency arbitrator within 1 day, and the emergency arbitrator has to get his act together and set out certain procedures within a 2-day timeline. The powers and the function of an emergency arbitrator ceases once a tribunal is fully constituted. The decision of an emergency arbitrator would lapse if a tribunal is not constituted within a 90-day period. Ultimately, whatever the decision of the emergency arbitrator, it is open to the tribunal to review that decision. More interestingly, the SIAC rules were recently overhauled, and there are new provisions dealing with multiple contract arbitrations, as well as joinders and consolidation. For multiple contract arbitrations and consolidations, generally this would be allowed in situations where the various arbitration agreements are compatible and either of the following occurs. Firstly, they arise out of the same legal relationship. Secondly, they arise out of a principal contract and ancillary contracts. And thirdly, the dispute relates to the same transaction or the same series of transactions. The new SIAC rules on joinder also allows a third party to be joined into the arbitration, and this can be done in a situation where the third party is prima facie bound by the arbitration agreement, and also in situations where all parties have consented to such joinder. So what is the arbitration regime in Singapore? The relevant legislation in Singapore governing international arbitrations would be the International Arbitration Act, pursuant to which we have adopted largely the 1985 UNCITRAL model law. The International Arbitration Act allows and provides for the enforcement of an international arbitration award as if it were a Singapore judgment, provided that the application is made to and sanctioned by the Singapore courts. An international arbitration award may also be set aside by the Singapore courts on the grounds set out in Article 34 of the UNCITRAL model law. This would include situations where the award has gone beyond the scope of what was agreed between the parties, where the award was secured by corruption or fraud, where there's been a breach of natural justice, and where the tribunal has exceeded its jurisdiction. It also covers situations where the subject matter of the arbitration was not capable of being decided by arbitration, or when the award is contrary to public policy. Where the award is a foreign-seated arbitration award, there is a further ground for setting aside the award, and that is where the award has been set aside by a competent authority where the award was made. Generally, the Singapore courts adopt an approach of minimal curial intervention where international arbitration awards are concerned. However, in situations which justify the setting aside of an award, the courts have a prerogative of setting aside the award or making a remission order directing that the matter go back to the arbitral tribunal for them to look into certain areas which may have been the basis of any setting aside. These would particularly involve areas where there might have been a breach of natural justice or where the tribunal had exceeded its own jurisdiction. I was recently involved in a landmark decision from the Singapore courts where the Singapore courts made a remission order to the tribunal, but eventually nevertheless went ahead to set aside the arbitration award, principally because the arbitral tribunal failed to rectify what was considered to be the grounds for setting aside the arbitration award. The other important area in terms of anchoring Singapore's position as an international dispute resolution center is mediation in Singapore. The Singapore government has been giving this a big push and recently formed the Singapore International Mediation Center, or SIMC for short. The SIMC has more than 65 international mediators, and many of whom are specialists in various areas, including maritime, construction law, intellectual property, and so on. For domestic disputes, the mediation process would be dealt with under the Singapore Mediation Center, and to ensure that professional mediation standards are consistently upheld, there is also the Singapore International Mediation Institute responsible for training of mediators. As some of you may know, the mediation process is not unlike a negotiation process in many ways, except that there is a third party overseeing the process, and that's the mediator. The idea is to approach it on a stage-by-stage basis to try to get the parties to eventually arrive at a situation which is workable for both of them. The most important aspect of mediation, apart from the fact that it might lead to a settlement, is the ability in the process of salvaging what could turn out to be an important business relationship between the parties. Let me also say something about what we call the ARB-MED-ARB process, that is the arbitration, mediation, arbitration process. Parties would typically start an arbitration, and after the pleadings are filed, they go into a mediation process. If the mediation is successful and a settlement agreement is arrived at, that settlement agreement becomes encapsulated in an arbitration award, and it becomes enforceable also as an arbitration award. So it combines basically the arbitration process with the mediation process and ultimately putting any settlement agreement effectively into the international arbitration award itself, and for which it can be enforced as an international arbitration award. Allow me to conclude by suggesting that if the opportunity should arise, that perhaps you should seriously consider Singapore law as a governing law in the relevant contracts which you may be entering into, and more importantly, also provide for Singapore as the dispute resolution center, particularly in respect to any arbitration. If you wish to have more information about Singapore law and our system, please do look at a website which has been provided by the Ministry of Law in Singapore, and that's singaporelaw.sg. Please feel free also to look at the Rajah Tann website. Thank you so much for your patience and your audience.
With over 650 fee earners in 10 countries, this is our home ground, our advantage. Lawyers who know Asia. Rajah Tann, Asia.